reach out to us, and we'll provide that information. And Lee can take it over from that.
Good morning, folks. Welcome. I know this was presented to you as a class, and that was a lie, and I apologize. This is more of a workshop. Okay? You all have this contract. There's no PowerPoint. I'm not going to be boring you with slides. We're literally going to be going through this contract, and you're going to be understanding. Now, I will preface this. This is one of 3 classes on this contract. We do a separate class on the standards, and we do a separate class on the addendum, because there's just not enough time for an hour. And you'll get to know why as we start to go through this. So what I want you to do is go along with me. The way that I present, the way that I speak, I love interruptions, I love conversations, I love questions, and I love them on the spot. So don't hold them, don't wait, stop me what I'm doing, we'll get to it. I want to make sure that everybody's following along as we go through it, right? At the end of the day, the goal here is to help you understand the contract that is used by 95+% of Florida when purchasing residential property, okay? So this is what we're normally using. We might as well get to know exactly what it says so that we can be rock stars for our customers and our clients, because there's a lot of opportunity in here. You'll also hear a couple of shameless plugs for other classes we do throughout this, only because some topics require further expansion, right? Some topics require a whole discussion, and you'll hear why in a bit. So don't hesitate to ask for our course list. Don't hesitate to reach out to Assure and tell them we want more of these classes or whatever it is, because there's a lot that goes on in expanding what we're doing here. So with that said, again, don't hesitate to interrupt me. Let's start off, and we're going to go with the first section. Now, I want you guys, everybody to know, in case you've never seen a contract before, in case you've never looked at it, on the left side of the column are numbered lines. We're going to go through those numbered lines throughout the day, kind of how we're going to mark this up, because I like to chew this in chunks, okay? So our first section is going to be lines 1 through 25, and it's the general, we'll call it the introductory section, right? So it gives us the parties. One of the main things I want you guys to take away from this is, when you're dealing with a seller, know that it's the actual seller. We've got more fraud than ever before in history combined in 1 year, as opposed to the aggregate of what we've been doing, and it's just going to continue to rise. As a side note, ask for IDs, ask for birth certificate, ask for anything that you can to help you feel comfortable with knowing who's selling the property. On the seller end. On the buyer end, here's a tip for you guys to be rock stars. On the buyer end, right? Ask your clients, not who's buying this, right? But how do you want to take title? Because how it's on the contract is how it's going to be written, right? So if they want to take title in the name of a trust, but they don't know it yet, there might be an option for you to make this contract assignable, and that's to your client's benefit. And we'll get to assignability in that section, but until then, start to ask these questions. Say, hey, listen, Joe, I know that you're buying this property, but are you going to be closing in the name of an entity like an LLC? Are you going to be closing in the name of a trust? Is this part of a estate planning? Something to that effect. I have a question.
You said you like interruptions.
I sure do.
I'm famous for that.
Right.
Here's a question on that buyer's name. One of the issues that we had, if a buyer comes in at, and this was something just happened last week, ABC Investment as the buyer, and they want to sign ABC, when we put it in there, title accepts that, but my attorney says, no, they have to sign their name as opposed to signing. So if it's Karen Lewis, I have to sign Karen Lewis as opposed to signing ABC Investment.
Right, so you'd be signing Karen Lewis, but underneath your signature should be the name printed, should be the company you're representing, and should be the capacity at which you're signing for, right? So those 3 things, once you sign your name, just like in a power of attorney, technically you're supposed to be signing your name, because the information is that you are signing on behalf of that individual. So you would sign, I would sign Lee on behalf of Eddie as power of attorney or attorney in fact of, something to that effect, right? So same exact scenario when you're doing it on behalf of a company, you should be signing the individual's name, right? Because the individual is the one signing, not the company, but in what capacity and representing which company should be on there.
And you need to make sure you verify that that person is authorized signer for that company.
That's a good point.
This
How
person
do
didn't
you-
wanna sign it, he didn't want it, because what happened, the agent had been letting him sign so long with the company's name, and so I told them, he has to sign his name on behalf of that.
Yeah, you can't just write the name of the company, because now we don't know who represents that
Who
company.
signed
So
it, right?
who's the authorized signature? Who's the authorized person of that
Sign.
company? So the one thing is, when you dealing with companies, the first thing you need to make sure also is to check, make sure they're authorized signer, because I can work for the company, but I'm not the authorized person to sign.
Right.
So we need to verify that. So a lot of times you ask for a court document, or you can go to some business, if it's a Florida business, so you can verify that, but you're always asking for a corporate document, so, for verification.
A real quick question, when he was saying make sure that the seller is the seller, you always look in the MLS, in the PID, and that's where you, is that not sufficient?
That's one of the ways to check, absolutely.
Yeah.
But you
But is
also,
that the person, is that the actual person who's signing, right?
right.
Well,
So
not
if you
always,
pull it
like,
up, if
in
you
her
pull
case.
up on the MLS and it takes you to the property appraiser,
Right.
let's assume for a second you see an entity and you have Joe Smith in front of you. Well, you look up the entity, is Joe Smith even named anywhere in there? Is he related to the entity? Or let's assume for a second you have someone in front of you by the name of Mary Smith and you look it up and you just want to make sure that it's the same person and you want to make sure their ID is good, valid, that they come to you. Unfortunately, realtors right now are the top targets of fraudsters in the state of Florida, because, there's so many realtors and so many agents that are not realtors that will just take a listing because the phone rang and didn't do their due diligence. And so it's really rampant right now. So you really do want to make sure that if you don't know who you're dealing with, if you got a call out of the blue, you want to double check and make sure that it's the right seller.
And from your perspective, your question is you you're representing the buyer in this situation that you were asking. So when that happens, is the title company will also verify that aspect of it. So if you go into the MLS, you see the seller's name, that's what you're gonna follow along. You're gonna trust that the listing agent actually verified the actual correct seller. So you wouldn't be able to verify that seller, but the title company will take that responsibility when representing the buyer. If we're representing the seller, that's what he's talking about. You need to verify and make sure that that is the correct person.
Okay, thank you.
All right, so let's continue on with our first section in the property description, okay? We all know we put the address, we put the legal, we copy and paste it from the MLS, we copy and paste it from the appraiser. That's a shorthand legal. Technically, that's not a proper legal description. It works because according to the general principles accepted in surveying, they can still find the property using the abbreviations, but technically it's not the right legal. And I've seen multiple times where parcels are left out, where it's not the complete aspect of what you're looking for. Maybe they have two lots together and that property ID is only for one of those lots, but they're trying to sell both. So I would tell you, whenever you're putting in your legal description in Part C, just confirm that it's everything that you're trying to sell. If you represent a seller, make sure that this covers everything that they're trying to sell. If you represent a buyer, make sure that this is everything that they're looking to buy, right? You just want to make sure of that. What I really like to talk about in this particular section is personal property. And this is one of those things where, like I said before, we have a whole class of top 5 reasons realtors get sued, and one of those top 5 reasons is fixtures, right? What is a fixture, what is not a fixture? And so this particular section tries to take into account personal property being sold with the residence. Remember, this contract is to be used with 95% of residential purchases throughout the state. Not everybody's gonna have draperies, not everybody's gonna have television wall mounts. It's one size fits all, right? And so you wanna make sure that when you go through this, unless it's specifically excluded in the blank lines below, okay? Unless it's specifically excluded, if it's listed there, it's included. So if you represent a seller and that seller has a family heirloom chandelier that is hanging in their dining room, and you walk in there and the buyer is doing the walkthrough, they're gonna want this chandelier. If it's not specifically excluded, it's included, right? And so the buyer wants the property as it's seen with the fixtures. It's not like you can replace the AC from a 5-ton unit to a 2-ton unit and take your 5-ton unit with you. At the day they see it is what should be there when they close. And so I caution people all the time when they represent sellers, if there's something that you want to keep, make sure it's listed in this section. If there's something that you want to keep, if you can, replace it before the first showing, right? You don't need to have the heirloom chandelier up. You can go to IKEA and get a chandelier and put that instead so that there's no confusion. The idea here in this particular section is a motto that I live by in law all the time, is just get ahead of it. Just openly and directly say, in the section below, other items excluded from this contract include family heirloom chandelier in the dining room. Take pictures, make sure you know what's there. If you represent buyers, this is crucial, right? You walk through the door and the buyer's blown away by this beautiful built-in, that should be a fixture, it should be included, and then when they move in, it's not there. Well, the good news is you took pictures and you're like, wait a minute, that's a fixture that should have been there and it's not excluded from our contract. So in this particular area, the first section, the most important takeaway that I want you guys to have is fixtures. Take note when you walk through what's there, what's not there. Take pictures. Ask your buyers, what did you love about this property? What is it about this room that you have to have when we close, right? What is in there? Ask your sellers, what are you taking with you from this property? What is not going to be included when you go through the walkthroughs? Ask those questions because fixtures are one of the top 5 reasons realtors get sued in the state of Florida. Our next section is section 2, lines 27 through 42 is our purchase price details, right? We're just gonna go over the general details of what it is that we're buying. We have our purchase price, it's pretty straightforward. How much are we buying the property for? Everything else is there. I will tell you, in this particular section, so it's rare for me to see one of these filled out where they have the purchase price, they have the deposit, initial deposit, if they have an additional deposit, the amount of financing, because when you're writing this contract up, you rarely know the amount of financing. So I would tell you common practice, whether it's accepted currently, it's accepted in forms of what it is that we're doing practically speaking, would be to write up percentage. Ask your borrower, ask your buyer who's getting a mortgage, how much of this are you financing? 80%? Okay, well I can do math. 80% of $100,000 is $80,000, right? So from that perspective, try to get it here as much as possible, and I'll tell you why. And this is going to be a crucial point when we get into our financing section of this contract. The more detail, when you represent a buyer, the more detail you put into this contract with regards to what they need to be able to close. They don't have $100,000 in the bank, they need $80,000. They need that money, right? And so if you left that blank and they were only approved for $70,000, then they don't have the opportunity to go back in the contract and say, hey, I told you from the beginning I need 80. And if I can't get 80, that's a problem because I need 80. And so when you don't put those numbers in for financing, it's one less thing that the buyer gets to say afterwards. The buyer doesn't get to say, hey, I told you what I needed and I couldn't get it, right? And so you want to make sure, try to be as detailed as you can, ask the questions. Don't be afraid to tell your buyer, I want to talk to your mortgage broker. I want to ask questions, or here's the things I need from your mortgage broker, right? You're going to be asking a lot of those questions because when we get to financing, there's a ton of information that you need to do your job. So that's really the emphasis on section number 2. Section number 3, time for acceptance. This is important, and we rarely use this only because in our reality, Florida real estate, once a contract offer is presented, usually response is made within days. If we don't put this in, time for acceptance, when we represent a buyer, that offer is out there. And we all know that it's out there until it's rescinded. So you don't want to put your buyer in a position, this is really the best opportunity you have to CYA when it comes to whether or not something as simple as the buyer's currently tied into an offer. Let's say the buyer submitted an offer, you didn't put that date in there, buyer ends up finding something else and puts in another offer, seller then signs the first one and sends it back, and now buyer's locked in under contract, right? So you want to make sure that you have a time limit there, a reasonable time limit, 3 days, 2 days, 24 hours, it doesn't matter, whatever the parties are comfortable with, but make sure you don't leave blanks. It's important with these contracts, the more blanks you leave, the more opening yourself up to liability for malpractice because of people not being on the same page. The blanks are here for a reason, and we'll get into specifics why. Closing date, section 4. As we get into closing date on section 4, one thing I want you guys to note on this is that it used to be we're gonna close on or before December 31st. On or before has been taken out. Now we're gonna be closing on December 31st. Why? Because if all the parties are ready before then, and all the parties agree to close before then, nobody's gonna complain about it. They're all gonna close before then. As soon as everybody's ready and they want to, they can. But it doesn't obligate the buyer. The buyer no longer has the obligation to close early if they don't want to, right? But buyers like, well, I gotta buy Christmas presents and I'm not getting paid until right before closing. I don't wanna close early. And so from that perspective, you wanna make sure that everybody understands we're closing on or whatever, on December 31st. And if everybody's ready early, we can still close early. Section 5 is unique, and this is a good thing for you guys to know what automatically comes with the contract. Section 5 is the first place we see in the contract where we have automatic extensions. The contract grants an automatic extension no matter what happens based on these two scenarios. In the first one, if funds from closing, pardon me, 1 second. Sometimes I talk and I choke on my own tongue. We have funds from closing are not available because of certain CFPB requirements have not been met, right? So we all know that loan approval and underwriting guidelines and everything else is there, on top of which lenders now have to comply with CFPB. They need certain disclosures to be issued a certain number of days prior to closing. And so from that perspective, in reality, you rarely see the lender give that 3 days notice of disclosures and whatnot. If it is adversely affecting the buyer, there's an automatic extension. Oh, we didn't get this disclosure and we can't close on December 31st. We need to close on the 2nd. That's already built into the contract. If it's based on CFPB requirements, it's an automatic extension on the contract. The other automatic extension is something called force majeure. It's fancy word for saying calamities out of your hands, right? At the end of the day, they've expanded the definition, and we'll get into that slightly. Actually, we get into it in depth in the standards. To include force majeure. I mean, we laugh, but as soon as the pandemic hit and nobody knew what was going to go on, before everybody realized it was the best time in the world to continue to buy, everybody wanted to get out of their contracts for force majeure. I need my money, I don't know what's going on, I might need to build a shelter, everything else that goes on with that. And they try. When the buyer buys this, if this property is used for rentals, the buyer is entitled to estoppels. We know estoppels from HOAs. Tenants give estoppels too. It's the same type of information. We ask the HOA for an estoppel. You're asking for all the account history, all the balances, everything, so that whoever's buying has knowledge from the source as to what's owed, what's not. When you ask for an estoppel from a tenant, it's the same thing. How much deposit did you put down? How much do you pay per month? How long is your lease? When does it renew? All that stuff to verify what the landlord has, and that's how you verify that due diligence. Usually done in commercial settings, also done in residential settings that are used for leases. And so it's important to know that if this is occupied, the buyer is entitled to certain things only if these boxes are checked. If you don't check this box, the buyer won't be entitled to the estoppel, you're gonna have a problem. And so it's important to know and ask these questions. Is the property occupied? Is it gonna be occupied? Is it rented? Is it Airbnb? Whatever it is. Question?
So if it's a condo and you're trying to find out if it has reserves or anything, you can ask the association for the stock as a realtor and get all the information about the assessments and.
In a perfect world, sure. Nowadays, what we're seeing is because of the new condo law in effect with regards to the assessments coming up, savvy buyers have been asking for 12 months of meeting minutes and proof of budget, to see if those assessments have been made, to see if the studies have been done, to see what it's gonna cost in the next 5 years to live in that condo. Because of all that, they've been asking, the associations are still taking the position that that information is only releasable to the seller. So you have to go through the sellers to get it. When the title company gets the estoppel, it's because they're doing it on behalf of the seller. So that's why they're able to secure it a lot easier. Usually they can't ask for, or usually they won't ask for meeting minutes or budget. But if you are the buyer, it is definitely something that should be asked for, and it's something that should be produced for review. Right? You want to make sure your buyer is looking at the declaration. I know no buyer looks at a declaration, but I can tell you, reading from a declaration, you'll know everything they're allowed to do, everything they're not allowed to do, right? You're buying a property that has restrictions and rules, and so you want to know what those are. I know people rarely read them, but it's important. Read those the declaration and the bylaws and get familiar with them, just to know what your rights are, what the rights of. How many boards operate today rampant without following those rules and regulations, and it really hinders the entire process. So, you know, we definitely want to make sure that our buyers are protected by having all the information possible. And this box in section B is where you would do that, protecting your buyers. If you don't do that and it is occupied, you're opening yourself up to liability. You don't want that. So ask those questions. Is this property occupied, or will it be occupied by a tenant after closing? And so the required, once you check that box, the seller then agrees to provide an estoppel by the tenant in order for you to verify all the rental information. The only exceptions are Airbnbs and short-term vacation rentals, because from that perspective, by the time the tenant is in and out, there's no reason to get an estoppel from them when it's a couple of days. And so these are for long-term, not longer term, as opposed to seasonal vacation rentals or Airbnbs, with regards to the estoppel requirement, not with regards to the disclosure requirement. Section 7 is assignability. Assignability is what we discussed before. You ask your buyer these questions: will you be closing in the same name that's on this contract? And if not, if you have any thought of a potential change as to who's going to be closing, you want to make sure that the contract is assignable. There are three options. Either it is assignable, either it isn't assignable, or either it is assignable. Yeah, you heard me. And so from that perspective, it's assignable and you get the old buyer off the hook, it's assignable, but the old buyer stays on the hook, or it's not assignable. Whether the old buyer stays on the hook or is off the hook, really is up to the seller, if the seller cares or not. Because if you put this as assignable and you're doing it for the purpose of the buyer wanting to be able to put it in a trust at closing, or they don't know what entity name they're gonna pick yet, you know, then it doesn't matter whether the buyer stays on the hook or not. It really is up to the seller whether they want them to. The reality is probably sellers would want them to. And from that perspective, it doesn't matter because of the buyer's purposes, right? If the buyers are wholesale flippers, then they want to be relieved of their obligations and liabilities, and sellers might not like that. And so you'll have that conversation. First conversation is with the buyers. How do you want to close? What name is going to be on your deed, on the title of this property? And then you can go back and forth to see if the seller wants to relinquish any sort of liability from the original buyer. All right, up until this point, everybody on the same page. Financing contingency is the beast, is the steak in this entire potato. One of the most important aspects of this whole contract is a misconception that 80% of people out here have, that it's either a deal is either a cash deal or it's a lender loan deal. And that's not true. A deal is either a cash deal or it's a cash deal with a financing contingency. What does that mean? I can come up to a seller and I can say, I'd like to buy your property. You're selling it for $300,000 and I happen to have $300,000 in the bank. So I would like to buy your property. I can buy your property. The other alternative is, I'd like to buy your property. I don't have 300,000 in the bank, so I'm gonna get a loan. Somebody's gonna give me a loan to buy your property. But if they don't give me a loan, I can't because I don't have the money. And so understand those are two different conversations. The second conversation, the seller recognizes the only way we can close is if I get my loan. And so this is the distinction you need to remember. Financing, all it is a cash deal with somebody else helping you close, and the seller understands it. So what do we need to do? We need to protect the buyer so that the buyer has the opportunity to say, sorry, I didn't get my money. And the only way we can protect the buyer is by going through this and understanding this particular section so perfectly, because there's so many hoops that the buyer has to jump through here in order for them to be able to have that protection. I like to use the metaphor of like an old knight's shield. In order for the buyer to have that shield, and that shield will say, I'm out of this contract because I can't afford it without this money, in order for them to have this shield, certain things have to be done. So let's go through them. The first thing, as a realtor, you will be checking off either this is a cash deal or this is a cash deal with a financing contingency. It is crucial to ask your buyer, are you getting a loan? If they are in any way, private doesn't matter, if they are, you want to make sure you check this off to give them a contingency, to give them a way out, okay? The contract is contingent, which means that the buyer can cancel the contract if he doesn't get the money within X number of days. Here's your first blank. Of the effective date, we're going to call this the loan approval period. So from the date that is the effective date of the contract, the date that the last signature is signed and the contract is delivered, once that contract, that signed contract is delivered and all parties have it, is your effective date. We're going to use the 30 days because of the blank, right? If it's 30 days from the effective date to 30-day period, that's called your loan approval period. And that's an important term that you're going to need to remember for a moment, okay? What I want to touch on, that blank line, is 30 days enough? Is 15 days enough? Is 45 days enough? Every lender is going to be different in this particular market. You have to ask your buyer's mortgage broker, how long do you need to get me a loan approval? Because they will tell you, I can do it in 10 days, and then 30 days is plenty. Or they can tell you, I'm 45 days back now, and it might even be 60, and you need this information, because if you go off that 30, you never ask that question, and the reality is they needed 45, they could have never done it in 30, that's you, right? That's not anyone else but you, and you don't want that liability, so ask those questions. How long do you need to get loan approval?
Say, they tell you, okay, I need 30, and they end up needing more. How does that, based on what you just said?
You need to have a conversation with the borrower and say, the numbers that I'm putting here, this 30 means that you're gonna do this by 30. It's the grown-up world, and we're agreeing to terms. And so if it's not 30, you're gonna be at the mercy of the seller to get an extension, or you're gonna waive your right for an approval. We'll get into that in a second too.
Can I add something to that?
Yeah.
At the same time is when, this is where you become kind of like a project manager in a sense, because in those days, you need to put that, as realtors, you need to put those particular dates in a form to follow along. Okay, it's been 10 days, check with the lender. It's been 15 days, check with the lender. When it's getting closer, you need to verify. So, because if you go in 30 days going to the seller, hey, I'm gonna need, they may be like, oh no. You know, so you need to be ahead of the game by following those days. So, and if you stay on top of the lender, they'll move quicker. You understand that? So once you notice it's been 20 days, you haven't heard anything, and you know on the contract to put 30 days, and he told you 30 days, you need to contact them, hey, we need this ASAP, and that's when you can put a little fire on the lender.
Also, 30 business days,
No, 30 days,
30
calendar
days.
30
days.
days, calendar.
Calendar days. The contract
Okay.
operates in calendar days unless it says otherwise. There's a couple of sections where it says no Saturdays, Sundays, or legal holidays, but
Okay.
otherwise it is calendar days. Now understand here, so you called up the mortgage broker, and the mortgage broker said, oh, 30 days is plenty of time, you can leave it at 30, and we can do that. That's great. Then we move on to the next question within the same paragraph, more blank lines, and I can tell you these blank lines are rarely ever filled out. These boxes are rarely ever checked. Why do I care if it's a conventional loan, an FHA loan, a VA loan, or something else? Why do I care if it's an adjustable or fixed rate? Why does that need to go into the contract? I'll tell you why. Two very distinct conversations that are completely separate. I tell him, I can't buy your property, I didn't get my loan. and none of this is filled out, and the lender comes back and says, Lee, we can't give you $80,000 on this $100,000 property because you wanted a VA loan, but you don't qualify, you're not a veteran. Instead, we'll give you a conventional loan and the rate is 12%. And so I come here and I tell them, I'm not gonna buy your property because I wanted this VA loan at 8% and they give me conventional at 10 and I don't have the money. And he says, I don't care, because you didn't put what kind of loan. When you specify the loan type, the rate type, the term of the loan, whether it's adjustable or fixed, all you're doing is strengthening that shield. The buyer can then come back and say, I'm only buying this property if I can get a VA loan at 4% for a fixed rate for a term of 30 years. And that's a lot stronger than the buyer coming to say, I'm gonna buy this property if I can get a loan. Two different conversations, and that's why it's important from your perspective. Ask these questions. You've already got the mortgage broker on the phone. What kind of loan are we going for? Is it a FHA? At what rate are we targeting? These are the things that you need to know, because at the end of the day, if the lender comes back and says you can only get a conventional, but I have over here a VA, then I have my contingency. It's not just any loan that will help me fund this, even though I can't afford the rate. It's the loan that I need to purchase this property. And that's where you come in. That's where your opportunity to say, hey, don't worry, you're protected in this instant. And so you want to make sure that you have that. So we promise in paragraph B that within 30 days, we're just going to go off that number for now, within 30 days of the effective date, we will be providing to the seller a loan approval. That is different from a clear to close. A loan approval from a lender just basically says, hey, we took a look, application, the borrower looks good, we're going to approve a loan for this borrower. There might be some property related conditions, but once those are satisfied, we can get to what's called the clear to close. And so from a lender's perspective, the loan approval is the initial, hey, we commit to funding this loan so long as certain things are done with regards to the property. And so that's what you'll see, that loan approval request. So we promise as the buyer, in order for us to preserve our shield, we promise to provide the seller within 30 days that loan approval, as well as, and this is new, as well as any lender-related approvals regarding appraisals. We used to, and I don't know how long you guys have been in this industry, I've been doing this for 17 years now, and before in 2006, 2007, appraisals were the way to get out of contracts. You get to closing and you didn't like this deal anymore, your buddy wrote that the loan is not approved because it couldn't appraise, and the loan was denied, and you're like, sorry, I'm leaving, the loan was denied, it wasn't appraised. That is no longer the case. If your lender requires appraisals in order for them to approve the loan, it has to now be done during the loan approval period. No longer can we wait to get to closing to say, no, that's a property related condition, we're not gonna get it clear to close. Specifically in the contract, we're not playing the games with appraisers anymore. If the lender requires an appraisal of the property in order to approve this loan, that appraisal approval must come within the loan approval period. I want everybody to understand that, because that's a crucial point, because oftentimes borrowers don't realize they actually have to pay for the appraisal up front, and maybe they won't be paying that fee because they don't think they have to pay it until closing. Well, you're not getting an appraisal until you pay for it nowadays. And so in order for them to be able to even get that process started, they need to understand that it's part of their loan approval period. So those are the two things that we promise to give the seller in order for us to be able to even hold a shield, right? We promise to give the seller a loan approval period as well as an appraisal approval within 30 days, regardless of what, in order for us to preserve our shield. Next, we say, okay, well, let's go into further detail, buyer, because I'm a seller and I don't want to keep my property tied up, and I want to make sure that you're actually doing what you need to do and not just pulling my chain, right? And so in order for us to do that, you want your loan and you want a VA at 4% in 30 years, that's fine. You can detail all that. Here's what I want. I want you to make an application within blank number of days. And what does that mean? It means you need to apply. Everything that the lender requires, you need to apply within a certain number of days. Now this is where a conversation you have with your buyers. You tell your buyers, hey, you want this loan and you want a VA for 4%, whatever it is, that's the loan you want. You need to understand that the only way that shield matters, The only way that contingency allows you to get out of this contract and doesn't allow you, the seller to say, too bad you didn't get a loan, we're still closing. The only way that that matters is if you make the effort to get the loan. You have to make the effort. We're no longer just doing this in order to play the games. So what does that mean, make the effort? You have to apply for financing within X number of days. The blank line says 5, that's more than enough time to go online and fill out an online application for a loan in order for them to do that. What happens after that? You promise to use a good faith and diligent effort. A contractual term that requires you to be fair and for you to actually do what you're supposed to do. And it's in there, and that's new, and it's in there because historically, buyers would play games. They wouldn't pay the credit fee in advance, or they would prolong something else in order to stretch the time. No longer. So what does it mean? What does it mean as far as good faith and diligent effort? If you don't use it, you're in default. So your buyer not only has to apply for these loans, you have an obligation to tell your buyer that they must use a diligent effort. Don't fart around. Get on it. If the lender comes back and says, we need 3 years of tax returns, don't wait 2 weeks to give them 3 years of tax returns unless you can show that you've been working hard every day for those 2 weeks. At the end of the day, if I was a seller and my buyer wanted to back out because they were not approved for a loan, I would want the details of every single one of these obligations, or I'm taking that deposit. I want that deposit because that's free money. And buyer, you obligated yourself to make an application within 5 days. Show me proof. Did you apply on the 6th day? Then you don't have a contingency. You promised to make a good faith and diligent effort. How long did you wait to pay the tax credit fee? 30 days before you even paid that off for them to move? You didn't show a good faith and diligent effort. So you need to tell your buyers, not only do you need to do this stuff, but you need to be able to show that you did this stuff on a good faith and diligent basis. That's the important part from here. So long as the buyer is jumping through the hoops to make sure that the integrity of their shield stays strong, in order for them to be able to do all that, once they do all that, that's when they can get out of this contract. That's when financing came back, loan conditions are not approved, we can't close this deal, buyer can get out of this contract. That's what the buyer wants. Buyer wants his property, but buyer can't buy it without a loan. And so you want to make sure that you have that. Now, in line 106, oftentimes we have issues with the sellers, and the seller's like, listen, I'm tying up my property. They wanted 45 days for a loan approval period. I don't know what's going on. Nobody's answering. Nobody's telling me anything. And before it used to be where the buyer was obligated to give the information, but really didn't have any teeth behind it. Now, line 106, and this is important for you guys to have in your pocket for when you're getting jerked around, right? Line 106, buyer shall, upon written request, keep the seller and the broker fully informed of the buyer's status on their loan application, on their loan processing, on their appraisal, yay, on their approval, and any other property-related contingencies. You have access to a lot of information when you are left in the dark. So understand that that is there in your favor when you represent a seller who wants to know what's going on. You know what though, but the buyer never ever complies and the buyer doesn't give me the information. Well, the good news is the next sentence. Buyer authorizes their mortgage broker, their lender, the title agent, to disclose the status and progress of each of those preliminary and finally executed disclosures, right? They tell them the buyer's authorizing this. So the buyer doesn't even have to give it to you. You can call the mortgage broker. You are entitled, buyer, release this information to your broker. So you're entitled to this information. You can call the mortgage broker. What's going on in this application? We're at day 29. I haven't heard from the buyer. I don't know if they even applied. I'd like to know the status, right? You're entitled to this. And you can send them the contract. Your client signed this contract. You are entitled. And failure to provide this information is a breach of the contract. And you want to make sure that you have that. Next section in line 11 says that if within the loan approval, the buyer obtains approval, the buyer shall notify the same before the expiration of loan approval. And that's new. Why? Used to be, buyer shall inform the seller upon receipt of the loan approval, buyer shall give the seller. That way seller, whew, he got loan approval, property's gonna move forward to closing, we're good to go. So we gave our buyer 30 days. They got approval in 10 days. They went to RU Quick Mortgages and they got approval within 10 days. And now fees are a lot. They're gouging them. The rates are, right? So the buyer says, listen, I've got this approval. I know now I can buy that house, at least with crappy terms that I'm okay with, but I want to shop it around. Buyers now have that opportunity. If they can get multiple approvals within the 30-day period, they can go ahead and pick and choose whichever approval they want. Buyers are now empowered to shop this around. And so the buyer doesn't have any obligation to give the approval until the expiration of the approval period. So if your buyer got one early and they want to shop it around and they still have time, there's no need to rush it. If the buyer wants to, they have that full time. If the buyer is just applying for one and that's what they want to do and submit it, that's fine too. They can do that as well. You can always submit it in advance of the 30 days, but you don't have to submit it in advance if they are shopping it around. On the other hand though, if the buyer is unable to obtain loan approval within the approval period or cannot timely meet the terms of the approval, after the exercise of good faith and diligent effort, we see it here again, contractual obligations in order for you to be able to stand in front of a judge and say, does this look like a diligent effort? Trust me, I got a 7 and a 9-year-old. Diligent effort is absent from their minds, right? Like, did you really do this with a diligent effort? No, you didn't. And so it's not difficult to tell if somebody's dragging their feet when you're in front of a judge, and that's why it's in the contract now, because the judge gets to ask, did you really do a diligent effort? Were you really acting in good faith? Because if so, if you're unable to obtain that loan approval, then during that period, buyer may terminate the contract by delivering notice of termination prior to the expiration of the loan approval period. It's very simple. This is what we want for the buyer, right? The buyer says, shucks, I couldn't qualify for that VA loan. I can't afford it at the rate they quoted me. It's been a pleasure. Let me have my deposit back, and I'm going to look for another property. I wish you the best of luck. If I hear anything, I'll let you know, right? We want to be able to do that as opposed to not terminating it and getting stuck moving forward with the contract. So we even have here that the buyers refunded their deposit so long as you're within the loan approval period, so long as you've been denied the loan that you were looking for valid reasons, then the buyers automatically return their deposit and the contract is terminated. The shield has saved the day and you have done your job as realtors protecting this particular customer or client as it comes to their purchase. Now, if buyer fails to timely deliver any written notice, if the buyer just doesn't deliver written notice to the seller before the expiration of the loan approval period, then the buyer shall proceed forward with this contract as if paragraph 8A cash deal was checked. So you waive your entire financing contingency. If you just blow the loan approval period, if your buyer didn't know that they needed to submit it, then you have waived the contingency to be able to get out when nobody wants to fund your deal. Now that deposit's at risk, now the seller can sue me for specific performance. My property's been tied up, I lost this and this and this. And then the buyer's gonna look at it and say, I didn't know I had to do all this. You know, we have these deadline checklist forms that we can give out. If you're not using them, start using them. Because the last thing you want is a buyer to look at you and say, you didn't tell me I needed to do this within 30 days, but you signed the contract. Nobody wants to hear that. Buyers don't care when they sue mortgage brokers, errors and omissions, insurance, who did what. They just want the cash to fall, and it'll fall somewhere at the end of the day. So use those deadline checklists. They are crucial. Make sure that they also have deadlines for the financing contingency. Make sure that they also have those deadline spaces in there. Those are important for you to use. Because if we blow those deadlines, it's not like the deal is dead. It's the entire contingency is dead, and the deal continues as if it was a cash deal. Now your buyer's in trouble. Now your buyer has to borrow, beg, or steal in order to get enough money to close that deal in order for them to not be in breach.
What if that, it can't happen, they try, but contingency is blown and they can't get the money?
If the contingency is blown, we're back to unfortunate real-world circumstances where they obligated themselves and now they breach the contract. Litigation ensues. Most likely they lose their deposit. Less likely but possible is they are forced by the court to commence with closing. I don't know how you take blood from a stone, but the court could order them to find private financing or seller financing or anything to that effect. There are unique and creative opportunities, but it's not a fun situation. And I can almost guarantee you the beauty about being a realtor is that when everything goes great, everybody's always so excited at closing. And the worst thing about being a realtor is that when things go south, you're the first to blame. You didn't tell me, I didn't know about this. You're the realtor, you're the expert here. And that's really what we're trying to capture is avoiding the possibility. When you fill out these contracts, not only are we filling them out, but it's important to take the time. That's what the deadline checklist is hey, I'm letting you know you've obligated yourself to some serious terms. This is $300,000 deal, right? This is not a $7 sub at Publix that if you walk away from, you'll just pay the $7 and move on. $300,000, there could be lawyer fees involved because the contract allows for lawyers' fees, right? So there could be a lot of obligations, liability, risk associated with this that really we need buyers to understand the gravity of what it is that they're signing. They're signing a legal contract to purchase a very substantial asset. So, if they blew the contingency, lucky seller. Maybe the seller just wants the deposit and they'll go away, and that's the best case scenario. If the buyer has timely provided written notice above and the buyer thereafter fails to close, the deposit shall be paid to the seller unless the failure to close is due to the seller or is due to property-related conditions of the lender. What does that mean? It means that the buyer got their loan approval within 30 days. The buyer submitted their loan approval. The buyer says, yes, we're getting this loan. The lender likes me. The lender's going to give me the money. Now the lender's looking at the property, and the lender comes back and says, sir, you got to fix that roof for $15,000 or else we're not going to loan it. That's a property-related condition. That's a hurdle that's stopping you from getting to the clear to close stage. So that's one of the ways that you can get out. The buyer says, that has nothing to do with me. He doesn't want to fix his roof. If he doesn't want to fix his roof, they don't want to lend me the money. If they don't want to lend me the money, I can't buy your property. And so that's why oftentimes we'll have the price concessions or they'll actually do the work. But this is where the buyer gets out. If the buyer preserved their shield, and at the end of the day, the lender came back and said, the seller needs to do this and this, or we're not giving you the money. Buyer has that shield and says, hey, they're not giving me the money, you're not doing this, I get to walk. And that's what this says. That's the beauty of this particular contract, is that if it's followed, if this contingency is followed, it gives the buyer opportunities to get out, not over-obligate themselves as that regard. Now, financing, as you've seen, financing, I mean, we talk about financing majority of this particular class, and that's why it's so important, because it's one of the biggest misconceptions that a deal is either a finance deal or a cash deal. No, this deal is a deal that obligates the buyer to buy an asset. Whether they need help buying it or they don't need help buying it is the transaction that we're talking about. And that's the crucial part of this financing contingency that I want you guys to take away of. The next section. I don't spend too much time on closing costs section strictly because the committee that writes these contracts, the FARVAR committee, I sit on it, and we are currently reviewing this particular section for modifications. So I anticipated by the end of this year, it's probably by the beginning of next quarter, that you'll see another revision to the contract as it applies.
You can finish what you're saying. I haven't skipped C and D.
Yeah, you're right, I did, and I'll be right there. So we'll go through this section, but understand that this section might be revised a little in the future. Obviously, I'll come back and I'll give a refresher if you guys want. So the question was C or D, and if you look at the way that the contract, the financing contingency, 8A is whether or not this is a cash deal, 8B is whether or not this is a cash deal with a financing contingency, and then 8C and 8D are whether or not the buyer will be assuming an existing mortgage or the seller will be providing seller financing. And the reason those boxes are there, because if either of those scenarios apply to your transaction, you want to make sure that's checked off, because it tells you need a rider, you need an addendum to go with this, and it reminds you. Anytime you see that opportunity to have a reminder, there's some sprinkled through here, see this rider or see this, that's where you need to pull that information, and that's where it leads you to. So you want to make sure you ask those questions as far as whether or not the buyer is going to be assuming the loan and whether or not the seller is going to be providing seller financing. So we talked about closing costs and closing costs to be paid by seller, doc stamps, and it's all there. Oftentimes, sellers rarely ever review this. They rarely ever say, why am I supposed to be paying the taxes on the deed and the transfer? Because that's a seller fee. So when they're asking what seller fees are, they're right there. Costs that must be paid to the buyer, those costs are right there. When the buyer asks, why am I paying those costs? They're right there. The confusion comes in with a portion of the contract that says, pick and pay, right? The confusion comes in when we have a seller that says, I'm paying for title, I choose the title agent, and the buyer comes in, all of a sudden the buyer's got fees. Wait a minute, I thought seller was paying for title. And so this is where the contract is currently lacking, I think, and this is where we have an opportunity as a committee to improve its efficacy, so to speak, kind of reword it a little. And so we want to obviously understand that title evidence and title insurance and closing date on lines 168 through 180 gives us the opportunity to dictate. Some counties, Palm Beach County, seller pick and pay. Palm Beach is seller pick and pay. Broward and Miami are usually buyer pick and pay. Every county in the state of Florida is different, but I'll tell you, I never go off of any of that because every deal is going to be governed by a contract. So I don't care if you're in Palm Beach, if the buyer wants to pick and pay, it's going to be on the contract and it's going to say buyer gets to pick and pay. What are they doing? They're picking the title agent, the closing agent, and then they're going to agree to pay those fees customarily paid by that particular party. Now, if you're the seller and you agree to pay for title insurance and the buyer is getting a loan, are you obligated to pay the taxes on the recordation of that loan? No, that's a buyer's obligation. Now, you are obligated to pay taxes on the deed because that's the obligation of the seller for the transfer, but the obligation for financing is still a buyer's obligation as it comes to that. And so we'll put some more clarity into this, but at the end of the day, you need to understand that even though seller pick, seller pay, or buyer pick, buyer pay, there still might be some fees as described in lines, where is it here, 136 to 154, that will go into effect that they need to know. From that perspective, that's really what I like to cover as far as the closing costs and whatnot until we do make the revision, but obviously help yourself to questions, comments, and concerns. Surveys. I like to know what I'm buying, and that's when I'm deciding between two different types of peanut butter. Then I'm looking at the shelves. When I'm buying a house, I like to know what I'm buying, so I'll get a survey. Oftentimes on cash deals, buyers will forego surveys. I could tell you, as a realtor representing a buyer, if your buyer ever forgoes two things, title insurance and surveys, if they say, I don't want title insurance, they say, I don't want a survey, you need to respond to them in an email, in writing, saying, I wholeheartedly recommend you get a survey for this property. It is my advice to you that you understand the boundaries of the property. You understand if there's any encroachments on this property. This is part of the buyer's due diligence. We don't talk about due diligence in a residential aspect often, but the inspection period is 15 days or whatever it is of due diligence. It's where the buyer gets to come in and sniff the paint if they wanted to. The buyer gets to do everything that they want to do to make sure that they are comfortable with this particular asset. And so the survey is no exception to that. So if your buyer is buying an asset, recommend they get a survey. If they don't want a survey, make sure you email them, say, hey, I understand you chose against the survey. I understand that part of my practice is to recommend these things. We find that it's always easier for people to understand what they're buying from the outset. And so I always say that home warranties are less common nowadays. They still exist on older properties with older appliances. Most new construction comes with a warranty, so you don't see them very often. Sometimes these are good incentives to get buyers to, the inspection report showed this and this and this and this. All right, well, I'll get you a home warranty and I'll pay for it. So that's in the contract there. Not a huge clause, but it's available. Section F, lines 188 through 202 I want to touch on because this is another misconception. Special assessments. We are not talking about assessments from associations. We are not talking about maintenance assessments from associations. We are strictly talking about municipal assessments that show up on the tax roll. Municipal assessments, assessments by the taxing authorities, okay, multiple authorities. These special assessments, the full amount of any liens imposed by a public body and ratified before closing in the amount of the body's most recent estimate, right? Who's gonna pay those assessments, if anything? If you live next to the Sawgrass Mall, you're in the entertainment district, that's CDD, you're gonna be paying an assessment on that, right? So who's paying what? And so we have two boxes here. And another opportunity for you guys to either shine or for you guys to leave these boxes blank. The first one says the seller is going to pay installments that are due prior to closing, and the buyer's gonna pick up the regular after closing, right? If this is a perpetual CDD, seller's not gonna be able to pay it off, so seller will pay the installments until they're gone, and then buyer will pick it up when they're there. The other alternative is seller shall pay in full prior to closing. If this was a garbage levy on improvements, and it was levied for 15 years, but the improvements were made 5 years ago, seller can pay that off and get a payoff. Those are what we're talking about. You don't want your buyers stuck with a seller's assessment, because that assessment ostensibly raised the value of their home. So your buyer's already paying for the effects of that assessment, just like solar panels, right? We say, are you paying off the PACE loan, or is the buyer gonna assume the payments? Well, the solar panels made the property worth $50,000 more. The buyer agreed to that $50,000 more price. Now the buyer's also accepting the payments for the solar panels. It's one or the other. So understand that you want to make sure that if the assessment is being paid off, if there are already assessments, look at the tax roll. The tax assessor's office will show you any assessments that are outside of standard taxes. Understand that if you do not check off any of these boxes, the contract conveniently checks off one of them for you. And it says that if you don't check off any boxes, Section A is deemed by as checked. If you're representing a buyer and Section A is checked, when Section B could have been checked, the buyer is going to be looking at you. Why am I paying? Why is this being prorated? I'm paying thousands of dollars on this assessment because we checked the wrong box. You don't want that to happen. Keep an eye on that. We're going to skip over disclosures. This is the section that I told you we have a full class on, as you can tell. But we go over everything from seller's disclosures, what's required, what's not, FERPTA disclosures, mold disclosures, flood disclosures. We go over everything that is discussed there, and I will leave it at that. I do recommend these being read, but I won't go through these because, as you can tell, this class is more than an hour to begin with, even without touching on this stuff. Property maintenance, conditions and inspections and exam, line 256 and down. This is buyer's due diligence section. This is where the buyer gets to say what the buyer wants. The buyer can back out of the contract because they don't like the smell in the kitchen when they did their first walkthrough. Buyer, at the buyer's own discretion, may terminate this agreement at any time. At their own discretion. They woke up today and they're like, you know what? I think the world will end tomorrow. I believe in the Mayan calendar. And I want to be out. And so they are out. Buyer at the buyer's own discretion to terminate it. So understand, in bold, because it's a double-edged sword. Buyer shall have blank. We talked about blanks. Talk to your buyers. How long do you need for your due diligence on this property? How long do you need in order for you to review the condo docs? How long do you need in order for you to get a survey? How long do you need before you get a home inspection? Do you need an engineer to inspect the foundation? Do you need a pest control to inspect for term? How long do you need, buyer, to do your due diligence? And the buyer will say, well, I don't know, I've never bought a property. What is due diligence? And that's when you tell the buyer, because this is where the scope of your expertise gets you into trouble over the unauthorized practice of law. You tell the buyer at that point, I wholeheartedly recommend a real estate attorney. Somebody that can help them through due diligence. Due diligence is not just for commercial. Due diligence is important for residential too. Buyers should know what they're buying. Buyers should know the inspection report caps their liability at what they paid for the inspection, and they could have paid more for a better inspection report. There's so much that goes into it. So when they say, I don't know, because you're asking the right questions, and if they don't know the answer to that, send them to a real estate lawyer. Tell them, hey, you need to go to a real estate lawyer. They need to advise you on your due diligence. Tell me how much time you need, and we'll put it in here. Don't guess, because if you say, don't worry, 15 days is fine, and it's not, it's on you. You want them to give you this number. You want to ask them, how long do you need? That way you can say, I asked you how long you needed, right? So you want them to give you this. So, unless buyer exercises the right to terminate granted herein, buyer accepts the physical condition of the property and any governmental, building, environmental, safety code restriction requirements subject to the seller's continuing the maintenance part, right? So you have 15 days to not like my property, but after 15 days, whether you like it or not, you've accepted its condition, right? If there's a illegal bedroom in the garage has been converted to a bedroom or a synagogue or something, right? If that's the case, and you waited 15 plus days, you've accepted the problem as is, right? That's the whole purpose from that perspective. That's why the buyer has such a strong due diligence.
Is there a maximum time?
As long as the parties agree. As long as the parties agree. I mean, as a seller, I wouldn't agree to an unreasonable amount of time. And if the buyer came to me and said, I need 45 days, I think that's unreasonable. But if they came with an email and said, because I have 18 searches and this is how long everything takes, and then I want 2 days just to look over, I'd say, you know what, that's kind of reasonable actually. So it really depends on the day-by-day situation of what it is that the buyer is asking for due diligence. It's all up to the buyer. Because the buyer can say, I don't need the condo docs. It's a mistake, but they can say it. So it's all up to the buyer how long they need. And if it's reasonable, if it's more than 15 days, if it's more than 20, 25 days, and you want to justify it, include why you want that time. But it's all depends on what's reasonable for that particular
The
deal.
common answer you probably guys would get is they don't know. That's gonna be the common answer they're gonna say. How many days? They automatically, just like you said, they automatically think it's just inspection period. A lot of realtors just think it's just inspection period, but it's not. It's due diligence. I'm sorry, I can't say that word. But it's literally more than just that. It doesn't HOA association. There's all these different things that takes into consideration, which a lot of realtors don't follow through on. They just think it just gets the inspection done. Oh, we'll just put 3 days. It's an inspection. No, it's more to it than that. You have to check the HOA. You have to check that. If you're gonna do a survey prior, because a lot of times you guys dealt with represent the seller. Never had a buyer ask you, oh, do you have a survey? Can you send me a copy of a survey? They usually you can ask the seller if they have that. For that, that'll help you with those things too. So just think of that. It's not just inspection though. So the buyer was gonna say, I don't know how many days. What do you think? And that's what he just mentioned. Now you're gonna put yourself in that position. It's like, you know what? That's when you can say, you can check on with an attorney, depending on the property that you are getting to. So you have to verify that. You can't just say, oh, they just put 10 days. Because that's a common misconception.
And that's a good point. A piece of vacant land out in Okeechobee that doesn't have any restrictions on it doesn't require a ton of due diligence. But a condo on Surfside nowadays probably does. Right? So it also depends on the type of property. That's a good point.
So, question, I have never asked for a survey for a residential. Is that, I mean, of course.
You wouldn't ask for one on a condo, and you don't need one for a condo, but on a single-family residence or on a vacant lot, listen, it's recommended, is it required? No. But if you're buying something, you should know where your borders are. You should know where the fence is. You should know if the building is built into a setback line illegally. You should know these things because, you know, maybe it was vacant land when the seller bought it and they put up a manufactured home, but they put it where they shouldn't have put it. And now you're selling it. Now the buyer's inheriting that problem because they didn't get a survey. All matters that would have been revealed on a survey.
Okay, so for resident, you recommend.
Yeah, I would say,
survey plus-
here's an example. 20 years ago, because I did real estate for a long time. Years ago, I had a residential property, and buyer purchased the property and so on. Didn't want a survey, but I recommended it. Didn't want a survey and so on. So it ended up. Next thing you know, there was a fence being put on in the backyard. When they purchased, the fence was already there. The neighbor already knew because that property was vacant. So the property was a vacant property, and the owner was overseas and so on. So the neighbor put a fence, extended their yard. So they were pretty much took over their yard. But I recommended to do a survey since it was vacant for so long, but they didn't want it. You know, because the seller didn't have one. I said, you definitely do one. So when they purchased it, now they're going to try to put a fence themselves. And then now they had to pull a survey, you know, and
With
they
their
noticed
own fence.
it's literally 5 yards.
Wow, so now they cannot,
It's because they already took it for a long time. Now at the
how long do you have to? 7 years?
They could.
7 years for an adverse possession.
Yeah, exactly. So at that point, he lost that. So if he had priorly asked for the survey and did that priorly, he would have noticed it, and he could have made the decision whether to still purchase the property or not.
Due diligence for the buyer, it's important. As we continue on to the next page, section B, that's still due diligence. It's the walkthrough, it's the final walkthrough. Your buyer has a contractual right to do a final walkthrough. What does that entail? You don't get to pick and choose. There are two things you can look for in a final walkthrough. Make sure that the fixtures you want are there, that they haven't been replaced, and to make sure that the seller has maintained the property in the same condition as when you saw it. That means that if there's a boat lift in the back and it's mechanical, and the day you saw it, it was beautiful and working, and there was a boat on it, and then you came back for closing and that boat lift is destroyed and rusted out and garbaged, that's not maintained, so you get to complain about that. Understand, there's two things, same thing on the seller side. You can allow them to do the walkthrough, but they get to complain about two things. Was it properly maintained, and are all the fixtures that you saw still there? You don't get to complain about it.
Is it the same one?
Yep, right, is it the same one, exactly.
They can replace the refrigerator. Is it the same fridge that you saw when they first started the property?
That happens.
Yeah, it happens often,
Happens
and it
often.
leads to litigation.
Washer, dryer.
Yep, they change it.
Top
And
5
AC
reasons realtors get
was not
sued.
working when I came, I had to buy a new.
You think copper piping is a fixture? When people, back in foreclosure days, and they would gut the house and take the copper piping,
Yep.
people would close and they would come in, there's no copper piping throughout the entire house. It's a fixture. Gotta do these walkthroughs, it's important. Top 5 reasons realtors get sued. Section C is important, why? Section C talks about closing out building permits. Understand now, open and expired building permits are not title issues. They don't affect the validity of title and of conveyance of title. Okay, what does that mean? That means that title companies don't care about open expired permits. You know who does? Buyers. Because now buyers have to deal with it. So if there's an open permit for an electrical rewire of this wall, and they never closed out the permit because they never got the final inspection, and now 10 years later, your buyer's buying it, nobody looks for an open permit, and all of a sudden they go to pull a permit on the ceiling, and the city says you can't have a permit on the ceiling until we close out the permit on your wall. Oh, and it's electrical, which means we need to take off the wall to make sure that it was done properly to close out the permit. And so now you have a disaster. Permits lead to disasters. Title companies don't always search for permits. Why? They ask for lien letters. We're all familiar with the term lien letters. It's a title company asking a third-party company to search the city's records for any liens, fines, etc. They don't always include open and expired permits because they're not title issues. Sometimes there's even an additional fee to search for open and expired permits. If you represent buyers, you want to make sure that the title company in their lien letters is getting a permit search so that your buyers can be aware. Same thing with the survey, right? Your buyers should know what's on the property. And if it's an open permit for an illegal, room conversion, they don't want that $50,000 headache to then have to fix it so that they can just get a roof so that they can get insurance. It's one thing after the other, and who are they going to look for to say, wait a minute, open and expired permits? I thought this was, and so what we have in the contract is something very important. Seller agrees to provide assistance and cooperation in closing out that permit. Wonderful, what does that mean? All that means is that seller is obligated to turn over to the buyer anything in their possession that could assist the buyer in closing out that permit. So if seller was diligent and took pictures and has receipts and has plans and has the blueprints of what they did behind the wall, and they have all that, they can give it to the buyer. The buyer says, hey, you don't need to take my wall down. Here are the photos, here's everything. Inspector can look at it, great. How often do sellers actually do that? And so this is great to have in the contract, but if the seller didn't keep any photos, if they didn't keep any invoices, if they don't have anything, then they are not obligated to assist. They're not closing out the permits themselves. They have no obligation to close out the permit unless you write it in the additional terms. They have no obligation to close it out. They just have an obligation to give you anything that they have if there is something. So
I have a
understand,
question.
that's a
I'm a
very
little
important
lost with
distinction. Yes.
So inspection does not take care of this? So this is in
Permits,
addition?
no. Inspections don't take care of open and expired permits.
So you have to ask your title company to do a permit search?
Ask them if their lien letters include open and expired permits. And if they don't, you can always call the city and ask for open permits on the property. Do I want every realtor to do that in every single deal? I personally don't think it's business practical, because there's already a search being done on the property from the title company, so I usually just say.
Assure America does check on that for you.
Yeah.
Just to let you know. Assure America does check on open.
Well, that's good to know. Right, so it's, and that's an important factor, because we don't usually consider open.
I never
records.
knew this.
Yeah.
Never.
I know that this is something that we automatically write into the additional terms we hear. That Dr. Karen makes sure that she put the macros in there for you to add it in the additional
Yep.
terms. You have to close out all open permits.
Open and
all-
expired permits.
Yeah.
Because there are things, some cities will say, some cities will tell you, oh, this is so old, we'll close it out, sorry about that. And some cities will make you get inspections, and the inspector will say, well, I can't see it, you're gonna need to tear it up. And the worst thing in the world is to have that happen, right? You just don't want to be in that situation. And so, understand that seller does agree to cooperate, but understand that that agreement to cooperate doesn't mean diddly if they didn't keep any records. The next section that we're gonna discuss is when we talk about assignment of repair and treatment contracts, this is just any sort of repair contracts or termite contracts or any treatment contracts that are ongoing with the property. Seller paid for 1 year of termite guarantee, and so that will transfer over. That provision just says it stays with the property. It's pretty straightforward when it comes to that. The escrow agent and broker, this is nifty. These two sections, section 13 and section 14, nifty. I always challenge myself to try to put a word in throughout the day. Nifty. I say nifty because it's cute. It's cute because this is where the escrow agent and this is where the broker attempt to relieve themselves of liability. This is where we say, hey, just so that you know, we told you to get advice, we told you to do this, we told you this is your transaction, you're buying it, we're not responsible, we're not liable. Buyer agrees to rely solely on professional inspectors and governmental agencies for verification of condition, and not on the representations of broker. I can tell you that these provisions have gotten 0 brokers out of a litigation that they were going to get into, okay? That doesn't mean they didn't win the litigation, it just means that it didn't save them from getting sucked into litigation. And that's what you want to avoid. I used to be a trial lawyer in my previous life, and in that, I would tell people, it's not about winning the case, it's about getting sucked into the system. Once somebody I can sue anybody for anything, it doesn't even have to be real or right. I can lie about it. It's frowned upon and I'll probably get in trouble, but I can still suck you in. And as soon as I sue you, now you have to defend yourself. Now you're in a system where you have to go through the process in order to clear your name. That's how it works. It is what it is. That's the system we live in. Anybody can sue anybody for anything. And so you better believe that anybody who's got an issue with a real estate transaction that was represented is going to be contacting that broker and getting that E&O insurance coverage information. Because they're going to be suing. Whether or not, oh yeah, but we're indemnified of liability and all that stuff. Yeah, but you know what? We'll find some negligence in there. We'll still sue you. Or we won't, and your insurance will either pay out or you'll win in court. But that's the problem. Now you're stuck fighting it. Winning and losing is just the end result. It's that entire stress, money, time, headache, lawyers, all that stuff that you don't want to even get involved in. The practice of real estate is scary, but you can do what you can do to avail yourself from opening yourself up to too much liability. This is one of those areas where we try to tell the buyers, and we tell them, buyers, make sure that you're looking at this. Broker advises buyer and seller to verify the condition, the square footage, and all the facts. Buyer represents the broker represents the buyer. That broker does not reside on the property, unless obviously they do. Then, you know, all the hold harmless, it's all great and wonderful. Once you get into court, once you're in the system, then at least you have a defense, but you're still paying for that defense. And that's what you want to avoid. Default, next page, page 7, we are in line 336, and we are close to the end of this class, this workshop. Default, buyer default. This is where we talk about what happens when buyer defaults. If buyer fails, neglects, or refuses to perform any of their obligations, including payment of the deposit within a specific time, seller may elect to recover and retain the deposit. Same thing on B with seller's default. If seller defaults, buyer gets to have their deposit back. Not always the most fair thing, but buyer gets also the option for suing for specific performance if they want, and asking the judge to force the seller to sell them the property. That is also an option. We talk about dispute resolution. This goes along with making sure that if there is a dispute, and there are disputes in real estate transactions all the time, if there is a dispute, we have a civilized method of resolving it. We have, buyer and seller have 10 days from the conflict to discuss the matter amicably and to go through, and if they can't resolve the dispute amicably, then they agree to go to mediation to resolve it. So it's in there. Now agreed, just because it's in there doesn't mean that one party can't rush to the courthouse to file a lawsuit. Absolutely. People skip mediation all the time and they go straight to the courts. So understand that the buyers and sellers agreed to have this 10-day waiting period of talking, but that doesn't, as soon as the breach is done, then you can technically get sucked into the lawsuit as far as that goes. And provision 17 is the attorney's fees. This is what gives unrepresented buyers access to courts, with attorneys that will take their case for free, knowing they'll get paid on the back end from the attorney's fees. We're going to skip standards. That is part of the disclosures course, and that really goes from the rest of page 7 all the way to page 12. That, again, standards with disclosures is an entire course that we go over in detail to go over each one of those things. I don't skip it because it means any less. I skip it because it does require a full course. We are on additional terms. This is a dangerous area for realtors. Oftentimes, we will write in additional terms. There is a very thin line between a realtor writing additional terms and a realtor practicing the unauthorized practice of law. I'll give you an example. If your buyer wants a power of attorney, Form Simplicity has a specific limited power of attorney. You print out the form and you give it to them. Are you practicing law? No, because you are providing them a form. You're doing what's called a ministerial act to provide them with a form that is authorized as a specific limited purpose in this transaction. If the buyer said, I don't want a limited specific, I want my daughter to have access to my bank account in the case they need to sign, and access to this and access to that, I want a general. No longer is it specifically limited to this transaction, now it's the unauthorized practice of law. That's how quickly it changes. So if it's not on the form, if there's no form for it, think to yourself, you shouldn't be providing it. For the same reasons, additional terms, unless you have approved macros, adding in these terms could be dangerous. I've seen realtors that will try to write it up as legally as possible as they could, and at the end of the day, the terms are missing what they need to be missing, and they're there. Now, I'm not talking about buyer or seller agrees to close out all open and expired permits. That's wonderful. But if they get something more complex, right? If this is involving 1031 exchange and you need to have certain aspects of language in there, get a real estate attorney involved. Don't hesitate to rely. There's people that you need to have around you, a good real estate attorney, a real estate attorney knowledgeable in 1031 in FERPTA especially with down here, a good tax accountant, a tax accountant that is knowledgeable in FERPTA and 1031. Those are important to have in your pocket, just to be able to call up and say, hey, I need some additional language. What should I write here? This is the situation. So that you're not just putting on, truthfully, I prefer you to give it to them to write up and let them handle it, not have it go through you. But at a minimum, get the language from a reliable source that you know that could lead to getting the point across that you want to get across. Additional terms are dangerous. Use them sparingly. If you need to use them, make sure that you're using approved language, make sure that you've reached out to an attorney, just to make sure that you're not putting yourself in hot water in the additional terms.
I have a question for you on this. I believe somewhere in the contract I have read that there are appraisal contingencies, that help the buyer if the property does not appraise at the price they agree to. But there is also here a checkbox for appraisal contingency. Would you must check that, or you don't need to?
So so we're discussing prior to the additional terms, the reference of the addenda, and we'll get to that in a second as well as far as all the addenda. But we're discussing whether or not you need an appraisal contingency addenda. If the buyer has an appraisal contingency on their loan, it's during the loan approval period. If the buyer doesn't use the addendum and the property appraises and they get the approval, no harm, no foul. If the property doesn't appraise and they didn't use the addendum, you could be liable for any issues with regard to the waiver of their contingency. And so it behooves you to use the addendum where it applies. Any addendum that applies, use it. There's an addendum, actually no, let's go through that for a second. On the page prior, line 588 and further, we talk about A through EE, different addendum. If there is a PACE loan, use your PACE disclosure, right? If this is a lead housing built before 19 whatever, when we used to eat paint chips, use that disclosure, right? You want to make sure that you are using these things when they're available to you and when they apply, including the appraisal. If you don't, you are opening yourself up to liability. Again, we have a class, part 3 of this workshop is the addenda and additional terms, comprehensive writer. We go through all the addenda line by line, just like we did with this contract, so you understand them all. And so from that perspective, you want to make sure that you are using the addenda that you need to use with this particular deal. That class goes through and tells you when to use what. The last thing I do want to touch upon on page 13 is new language. New language for foreign buyers. We all remember the Foreign Buyer Act that was recently passed and put into law and is causing so much ruckus throughout our entire real estate industry here. Well, that language has now been codified. We have put it in a giant box right above the signature line to make sure that everybody's aware that part of this Florida statute limits and regulates the sale, purchase, and ownership of some properties in Florida to some buyers that are associated with foreign countries of concern. It listed 7 different countries of concern, and currently lets everyone know that it is a crime, a criminal act, to buy or knowingly sell property. So if you are involved as the realtor knowing that the buyer should not be buying this, if you are involved as the realtor knowing that the seller should not be selling this, you are complicit in a crime, in an actual crime that is violation of the act. I'm curious if they would list that as an act of terrorism. I'm curious if they would pursue that. Because you have foreign buyers from countries of concern.
Probably would.
I don't know. I mean, you talk that, you lose your due process rights. But either way, I digress. It says that at the time of purchase, the buyer must provide a signed affidavit. This is new. Every transaction in the state of Florida is not going to have the buyer sign an affidavit at the time of purchase that says, I'm a buyer, I know about this law, I checked on this law, I checked on the property doesn't comply, or I'm not party of the foreign countries of concern. And so from that perspective, every buyer is not going to have to sign this, and buyers that can sign this won't be able to buy the property. This is the thinnest line you have between you all and fair housing violations, right? You can't not work with someone because they are from China. However, they can't buy property, and that is your business. And so it is a lot of give and take. There's a lot of guidance still coming out on this with regards to how to act, how not to act, what disclosures, what not disclosures. FREC just came out with the affidavit that they want every buyer to use. That's been published, and that'll start coming out in the closings. That's going into effect as of January 1st. You might actually already see it in effect as well. So from that perspective, folks, that's the last thing I want everyone to know. It's important for, in that perspective, foreign buyers, if you have a foreign buyer, if you can ask them, hey, do you have any relation to the People's Republic of China, the Russian Federation, Islamic Republic of Iran, Democratic People's Republic of Korea, the Republic of Cuba, the Nicolas Maduro regime of Venezuela, because if he's ousted from power, Venezuela's off the list. It's a complicated issue over there, and the Syrian Arab Republic. So yeah, I guess ask in advance, do you have any contact with any of these? And if so, go ahead and go to an attorney and find out if you're allowed to buy this. Don't give them advice. Don't say, oh, you're cleared. Oh, you can buy. they need to check the law with an attorney and make sure that they don't fall into any of this, because the criminal aspects of this are astonishing.
Especially at the beginning now. Yeah, so, this is something we're not gonna get in trouble for asking because it's a part of the contract.
Oh, sure you will. That's the current conflict right now.
Yeah, that's the
Realtors
conflict
and
where you
fair
said
housing.
fair housing and this, that's what it,
That,
that's what it's talking about.
nobody, before they passed this law,
But-
nobody said, how does this affect realtors
Here's
and
how,
fair housing?
here's how you can protect yourself. It's in the contract. You need to show it to your client to make sure they understand that what's that page is, okay? And at your own discretion, you would understand, you would know the difference. So the whole thing is, when you go to that section, you have to read it to your client, because a lot of time right now, we have e-signing, right? You guys send it for them to sign. A lot of times they don't read it, you just
They don't
Uh-huh.
read
um,
it.
Before you have them sign, you need to explain that section, especially you would know, if they look at an agent saying, obviously use your own discretion and so on. But you need to explain that section to them, saying it is a crime in regards to that. You're protecting yourself in regards to fair housing, you're not saying that they are,
Right.
you just
so-
mentioning what's on it.
But then it's your word against the person.
Right, and so what you could do, what you would do,
Email.
you would email a copy of the contract and say, you know, by the way, really realistically, it's even before they sign this contract, so when you send them the contract, I would add a note to say, please note that there's a box right above the signature line talking about foreign buyers. Please review this. If you don't understand it, please get with the lawyer before signing.
CYOD.
Cover your own.
I say
Assets.
instead of A. But the whole thing is cover
Wait,
yourself.
D?
Yes. That's what my dad says.
I'm afraid to ask what
Yeah,
that means.
you know,
I'm gonna ask him after
That's
the
why I said
class.
that's what my dad says.
I'm gonna ask him after the class. I'm
So the
afraid
whole
to ask
thing
that question.
is, by sending the email with that information, you are covering yourself in case if they do lie. Say, hey, this is the situation, this is what I mentioned and so on, and you did advise them to see an attorney, and you did went above and beyond by just having time. Go ahead.
What if they're married to a US citizen?
The law doesn't care.
So,
So if they're,
wait a minute, wait, so,
This is a rabbit hole.
Yep, it is.
if
that's why I leave it for last.
If they are married to a US citizen, the US citizen can purchase, but they can't purchase. If they're married, how does that work?
The US citizen would purchase.
U.S. citizen.
Huh?
Or they don't have any?
What happened? Say it again. Say it again.
No, spouses,
The
spouses
US
have to-
citizen
How
would
does that
purchase.
work in Florida?
Exactly,
What do you
that's where I'm a little confused.
If you marry, I thought.
You have to, married couple have to be on the deed, but.
So technically, the legal requirement of a married couple to be on a deed together is solely for the purpose of them getting tenants by the entirety protection. So if the property is in my name and Eddie and I are married, if the property is in my name, you should be happy about this. If the property is in my name only, we don't have tenancy by the entirety protection, meaning that if there's a judgment against me, if it's not my homestead, it's gonna attach. So there is a downside to it. But if Eddie's part of one of these 7 countries, he can't own property in the state of Florida. Even, so let's take it a step further. It's in my name, I say, you know what, I'm the US citizen, I'm gonna buy it, and the next day I get hit by a car and I'm out. Eddie can't even inherit that property. Eddie's now gotta register that Eddie's inheriting that property, and Eddie has to sell that property within a certain amount of time. Eddie cannot maintain holding that property.
Does that go for a quitclaim deed after the situation?
A quitclaim deed for what?
Chad?
Yeah, oh yeah, Eddie cannot own it, whether by quitclaim deed or otherwise. Eddie's not allowed.
But do
So
they
if I'm
have
looking
you
for
fill
Cuba-
out that form again?
Oh, they want another list?
Yeah.
They should.
I have a feeling this list is gonna get much longer.
This is kind of prejudiced.
Yeah,
So this
we've
is-
had meetings
Yeah.
for,
It is prejudiced,
For-
completely prejudiced.
yeah.
I'm married to a Cuban, I can own it, but he can't.
If you're married to a Venezuelan, no.
So if they get divorced the Cuban guy have to sell the house. He cannot
If
keep it.
if he gets
If they
awarded
get-
the house, correct, he has to
He
sell
might
it.
die
That
too.
if you,
Yeah.
no, but if you
He
get
has to
divorced, you
sell
have
the
to sell
house.
the house.
Yep,
Or
keep
whatever,
it.
he cannot keep it.
yep.
But why why just Venezuelans and Cubans and China then for that,
politics.
take the whole
That's-
South
that's
America?
politics.
That's
I mean,
politics, look at the
That's
list, that's
politics.
politics.
Yeah.
All
If you
it
look
is
at it, it's all
This
politics.
is so prejudiced and our country is not supposed to be
politics.
prejudiced.
So, in the event that, in the event that, you know, the case is that they're married and, the person says that they, you know, they can purchase the property, they're not, affiliated with, or they don't belong to any of these countries. But, it turns out later on that they are.
As long as they're signing that affidavit of closing, that's why it's required on every transaction.
So it's not our fault.
It's not your fault, they signed an affidavit, now liability is strictly on them.
Oh.
Yeah, that's.
Now, wait.
But if you don't-
Hold on.
There's more
Hold
to it.
on.
There's more to it.
In the event that your email chain shows, oh, I'm working from home in China today. I brought you a gift from China. If your email shows that connection, no matter what they say, if somebody says, yeah, but they were obviously lying and you obviously knew they were lying and you didn't say anything, you're sucked back in.
But even if,
So
but
be
if you're
diligent.
oblivious to it and you don't know,
You
you still suck into it.
Officer, I was oblivious to the speed limit.
No, but if, because there's a lot of people who work remotely.
Yeah.
Okay, you know, there are some people who work and, you know, they live here and this is their homestead, but they travel for work and they're somewhere.
But a lot of times,
Venezuela.
what you have to understand though, you're thinking about US citizens who's traveling, living in China, and you get an email from China, but they still a US citizen. The whole thing is, if they are, with those particular,
They're not
say
a citizen.
they're not US citizens, or they are one of those, and they're actually sending an email from that particular country, or sending, and so on, that's when you're aware of one of those categories, so you have to bring it up. If you never said anything about it, that you're aware of those situations, and you give them those, and you notified them, then you would be liable. You would be you'd be involved in that situation. But if you already bring it and notifying them, hey, this is the stipulation, and also give them the affidavit, instead of affidavit, give them the affidavit at that point, you protecting yourself, because they say, hey, yes, I work there, but I'm not affiliated with those situations, I'm not this or whatever. Now you're protecting yourself. You're protecting yourself. It's literally trying to be oblivious of trying to say, hey, it's $1 million sale, I don't know. I don't want to, it's kind of like, I don't know. They told me, oh, they not. Well, I'm just gonna get, now all of a sudden, in a sense.
The best thing, whenever you send out a contract to a buyer, send a copy of the FREC affidavit.
Right.
And tell them, this law now applies. You should check to see
That's
if
a
you're
good-
covered,
That's
you're
good.
gonna have to sign the following affidavit of closing.
That's it.
Send out the
And then now you're protecting yourself.
Yeah, I like that.
Chose the right profession, huh?
It's getting better every day.
I tell you, of all the classes we offer, this truly is my favorite, because understanding the nuances in this contract we rarely get the opportunity. We hit the ground running, and real estate moves so fast that, you're just working and hustling and trying to get business. It's important to know what people are signing and what to do to protect yourselves, so. I hope that we are invited back for the second and third workshops.
Oh, you are definitely.
I'd like to be able to continue to go through those with you guys, but otherwise,
Absolutely.
thank you for having us on part one.
Oh, please, thank you so much for doing it.
Thank you.
My pleasure.
It's so important.
Wow, okay.
I have a quick question, and I don't know if you can answer it. I went over but I came into an MLS representing the buyer, and it says on, how they put their remarks? They put showing instructions, blah, 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 and then it says, no commission on retained deposits. If buyer defaults, no commission will be paid to either broker on the deposits retained by the seller. Should I be,
If you represent the buyer, that shouldn't concern you.
Well,
It's just.
here's the thing. Commission is owed when a broker provides the seller with a buyer that is ready, willing, and able to close. Commission is earned, you don't have to wait till closing. So technically, the commission is earned upon the effective date of the contract. When there's a default and the commission goes to the seller, that commission is still owed, but when you sign that, you waive your right to it. So if the selling broker has offered compensation, cooperative compensation of 3%, and then they put that language in there, you're giving up your right to 3% that's technically owed. At least to you, they can waive theirs, but as it comes to your 3%, you brought that buyer, your buyer's fine, there's no reason not to. Seller breached, why should, or whatever the breach was, this was a good transaction.
if the buyer defaults, they said.
Right, whatever it is,
It's
at the end
So
of
how
the
do I
day,
deposit.
protect myself as a realtor?
not agree to sign that, or say only seller's broker.
Yeah,
Don't speak for my.
The thing is, they speaking, what they speaking about is in regards to the deposit though. It's saying the deposit, if there's a breach of contract through the buyer, the buyer's broker is not obligated to any part of the deposit money if the deposit is being held by the seller. Actually speculated, say brokers, means selling broker or buying broker is not gonna be participating in regards to the deposit. That's what usually when you get, I'll explain to you. Usually if you are representing the seller and there's a deposit, say for example, a buyer put a $10,000 deposit. Now buyer defaults for any reason and now the deposit is being held.
In the escrow,
Okay,
yeah.
by deposit being held, in a lot of situations, it is the selling agent can get a partial of that deposit.
Correct.
I mean, think about it,
So.
But
yeah.
I'm about to write the contract and I
But for
don't wanna
you-
sign that, so how
Yeah,
do I
you
put
can
it?
cause all it's saying, literally all, my understanding, I could be wrong. From all it's saying from regards to that is if your buyer defaults,
Yes.
you are not getting, and the deposit is being, seller's taking over the deposit.
Correct.
and the
Okay.
brokers aren't getting their
The
commission.
brokers are not getting
Correct.
any
But
commission.
understand, the commission is not earned at closing, it's
It's
earned
earned.
upon contract signing. You did your job. Your job is to find a ready, willing, and able buyer. You found that buyer, you are entitled to your 3%.
Right,
If you agree to that and include that language in your contract.
but buyer
you waive-
defaulted.
That's fine, I don't care what defaulted. Buyer's ready, willing, and able when you brought it, right?
So
If
I will
seller's
not
entitled to the
put that in the
commission,
contract.
if the seller's entitled to commission, the buyer's broker is entitled to their compensated, their cooperative compensation as well. And just because seller wants to waive it because maybe their or seller's broker is buddy with the seller and says, you know what, if you get the deposit, I'm not gonna take anything, they can't speak for the half of the commission that they've offered the world. They can only speak for the half of the commission is theirs. You have to agree.
So if you were me, what would you do?
Do you like working for free?
No,
Then I would sign it.
so I won't sign that, okay. But I'm the one who
Remove it.
writes the,
I mean, listen, there's also a possibility that the deal closes and nobody defaults, and
defaults.
it's not an
Correct.
issue. But you know, this matters when you're dealing with a commercial transaction and the cooperative compensation is $75,000, right? That's, your 3% is $75,000. And they say, well, if this deal falls through, we want you to walk away from that. You're not gonna walk away from
No.
that. Why would it make any difference if your rate is $7,000?
Correct.
Money, listen, that you've
I
earned,
don't
this
wanna
is your
leave money
job.
on the table,
Yeah.
correct?
Yeah.
So do not, okay.
So what was the question?
If the commission is still owed,
It's, the question
whether or not you waive
was,
it was up to you.
the question
It's a
was,
stipulation that
in the MLS, the broker put a remark saying, no commission on retained deposits. If buyer defaults, no commissions will be paid to either broker on the deposits retained by the seller.
Yeah, for the escrow deposit. So no, because usually in a default or whatever the situation, if a deposit is held and now the default happened, commission is still being part of that deposit.
Yeah.
Selling agent can still get a percentage of that deposit, and buyer's agent can still get a percent of that deposit. So, and ultimately, the deposit can still be split in a commission. But ultimately, if you represent the buyer, I'll be honest, ultimately, if you represent the buyer, you're fighting for that deposit not to be taken, period. So you're not worrying about the commission on that in essence. But if it does occur, you still are obligated to still get your commission from that. So what this particular seller is saying is, I ain't paying nobody.
I'm taking all of that.
I'm taking all of the deposit. I ain't paying seller's agent or buyer's agent.
And that's
what
that's fine, it's just a contractual negotiation term,
it's a,
right?
yeah, that's all it is.
There's nothing wrong with it, it's just if you agree to take the listing on that condition or not.
Yeah, you can say fine, or you can say, no,
I
don't
can
agree
say,
with
I
that.
put an offer, but I am not signing.
You can also do that,
You can also do
That,
that.
that,
counter offer,
You can
right?
kind of offer and just kind of say, no, I don't agree to this.
I have a good
stipulation.
offer, but I don't agree to
But
this.
you can also, because the whole thing is trying to fear anybody who thinks the buyer is
Correct.
not qualified or not really serious. or
Because
anything
they
like that.
already
That's what
had-
they do.
You wanna take it a step further?
yes,
So you can email them back, I'm not taking it with this contingency, but then are you violating your fiduciary responsibility to put your client's interest ahead of yours?
Yeah.
I don't have an answer to that question, but it's something to consider.
To consider.
It's something to talk to your client about and say, hey, the only way this is working is if you breach, I don't get paid. And last time I checked, I can't pay my light bill with wishes and kisses. Like, what are we gonna do here? Maybe your buyer needs to compensate you, but that's your decision. You need to know that if you're gonna deny this without the conversation of the buyer, just because it's your commission, then you might be crossing that line between putting your interest ahead of your clients. Who knows?
and that's my daughter, the client.
Who knows?
So
I'm
that's-
just saying.
Yeah, so that's it. It's all in negotiation regarding to that aspect. So just understand it, a lot of realtors, they don't understand that, is that deposit, if it is being taken over by the seller, you still can get part of that commission on that. But when you're representing the buyer, you are fighting for your buyer's commission anyways. So you're not, you're fighting for the buyer not to lose that commission so they can continue to be able to purchase the next property. But still.
Do you think that's gonna be something that we're gonna be seeing more of?
I think, so that's an interesting question considering the new litigations involving NAR and cooperation and everything else that's going on. There are some theories floating around of what this industry will look like after the litigation. Some believe that we're no longer gonna be seeing cooperative compensation. Buyers will pay for their own realtors, sellers will pay for their own realtors. There's some talks about seeing, okay, well, maybe realtors' fees will turn into flat fees and not percentages. As far as that goes, who knows? But this is the reason why the issues came up. So do I think we'll be seeing it? I think that a lot of people are gonna jump onto these class actions, and I think that it's gonna change our industry. Wait and find out, but I definitely think it's gonna have some impact.
Yeah, I read something about the flat fees, that they were looking into flat fees.
Mhm.
The flat fee's been there for a while. It depends on which realtor and how they do it. So I know a lot of realtors who just do flat fees. And,
Access to the MLS, everything else, everything will change. I
but
think
there,
this
but
lawsuit
the
will
customer
change
service
everything.
in the service section is down because they not getting as much as, it's a little different. But we'll see how the industry changes. Because there's a change coming within the industry. But I'll say one thing is, smart and strong
Will
still
survive.
be making a lot of money and will still strive
Yeah.
in this industry.
Yeah.
You have to be the smart one and you have to understand what's going on. And the education process of it is very important. As you educate your buyer, because a lot of times buyer don't understand. As you educate your buyer, you still be able to still prosper from this industry. I've been in the industry for over 20 years, so I've seen the changes. So it changes all the time. And you'll see some come and go. in the industry, some real estate will come and go, oh, this is too hard, or this is, oh, what is going on? Oh, you're not gonna get paid? Well, educate yourself, understanding exactly what's going on, and how can you benefit from it, and how can you actually, train. It's literally education process.
I'm gonna stop my friend from talking as I see that we are well over our time, and I don't like to steal your time.
Yes.
But I do thank you guys, obviously, for having us here, and I hope you enjoyed the class, I hope you learned a lot, I hope you took some notes. There's some great information in there, and otherwise, thank you guys, and look forward to seeing you again.
Who knows how to write up a contract right now?
Thank you.
What does section 3 mean?
I didn't say there was a quiz.
Well, oh, Julie, I gotta give you your thing too, okay, all right.
Thank you so much.
Okay. All right, so you two, we're signing off, and we hope you all got something too. What's section 4?